Well, regardless of what type of dispute you're involved in, the usual rule is that you have to engage in some sort of pre-action or pre-court proceedings, correspondence, negotiations, etc. with your opponent. The courts have set protocols or set procedures which are called protocols, which set out the steps that parties are required to take to try and resolve their disputes before they go to court. The reason for that is that the court doesn't want to be clogged up with disputes which really shouldn't be there, and often you find that disputes can be resolved between the parties more cost effectively without involving lawyers too much before they actually have to go to the step of issuing court proceedings. And the consequences for you if you don't follow those pre-action protocols before you issue proceedings are that even if you win at court in 6 to 12 months' time, or however long it might be, then you can be penalised on costs. So the usual rule is that the winner would be awarded their costs of court proceedings. But if you have just launched into court proceedings without even trying to engage with your opponent, then the court can look at that at the end of the case and say, you should have complied with these rules, I'm not going to give you your costs, or in worst case scenario, you have to pay your opponent's costs. So it's very important to engage with your opponents